Welcome to the Exhibit A podcast.
Louise Nixon, how are you?
I'm great. Great to see you. Great to see you, Don. Thank you for inviting me to your podcast.
Oh, of course. This is your second time. And when Carlton Mays, who's with us as well, indicated that you'd be interested in joining me, I'd jumped at it. Carlton, how are you?
I'm doing fine. Thank you, Don. Thanks for having Louise as a follow-up on one of your podcasts. We appreciate it.
This isn't a follow-up, my friends. Okay, I'm going to have her on here regularly. This is one of the most impressive ladies that I know. Entrepreneur, great attorney, Pasadena resident. I introduced you before, Louise, but if you don't mind, I'm not going to go through your resume this time. Is that okay?
Yeah, that's fine. Absolutely.
I want to get to the meat of things. You know what I'm talking about?
Yeah, we got a lot to cover.
Yeah, we do. First of all, we need to talk about this virus thing, man, and staying at home. How are you doing, by the way, with all this?
We're good. I mean, we had already set up a lot of virtual stuff, but it definitely, like your firm, right? I mean, it's in your office. We are working remotely, so it's definitely, and we've buckled down.
Isn't there an old expression? You make steel through fire. Get through fires or something like that. But I really think that people that are like you that come out at the other end of it even stronger. It's because you're perseverant. So I attended your webinar recently. Maybe Carlton, you could give us a little description as to what this new thing is where your Quadrille Counsel is giving webinars.
Yes, the webinars have been in a series. We actually have our fourth one coming up this Friday at 1:00, which has to do with Federal Employee Retirement System plan, so FERS. We've had one on judgment language, and so I think we're going to touch on some of that in this conversation. The other one was on using our calculation suite, and the first one had to do with joinders and notice of adverse interest. So different topics. They're about an hour long with one of our experts speaking on the subject, and they've gone very well. I was going to follow up on what Louise was talking about. One of the things we've noticed with this, with the virus and remote access and work is that how well the program does work, because all of her dozen support staff people are all working remotely and supporting the program. So that's been a real positive to actually witness firsthand, and the attendance numbers each week they've increased. So that's a nice trend to look at.
Yeah. So for all of the audience that didn't get the benefit of watching our first podcast with Louise, I need to kind of go back a little bit. And I'm going to do that, first of all, by sharing my screen and showing you what Louise's company is all about. If I can find it on this thing. Here it is. Okay. So Louise, this is your website, Quadrille Counsel, legal technology company for pension division, something you created, showing how innovative you are. Can you describe what the company does for people?
Well, the goal is, depending on how you want to use it, is to make access to the Division of Retirement Benefits from the beginning of a case to the end, or wherever you are in the case, to make it accessible and be able to provide, through the use of technology, the information that you need to know to handle pension division, whether you're an individual, whether you're a law firm, or whether you're a court, nonprofit, self-help center, because all of these different variables, all these different types of situations, they're all involved with Quadrille Counsel, and it's been a really great success. There's a whole team. It's not just me. I had the idea. There's a whole team of people now behind us. There's about 5 or 6 experts involved. So it's a lot of people working on this, and it's exciting to be part of something bigger than what we're all doing. I mean, when we talk about this, Don, you know the situation with the retirement plans. You see them every time you get a case. I think about that in the United States, there are 1 million divorces a year, and there are only about 40 quadro attorneys or quadro professionals handling pension division. I mean, the numbers just don't add up. So you have these laws that are there to protect the parties, but unless you're a great attorney like you are, I mean, people aren't even going to know what to do. And so what happens is you have these laws, but nobody knows how to divide them. So the reality is that a lot of people never get their share of the pension.
Yeah, we're going to talk a little bit about some of the mistakes people make with regard to handling quadros, and mostly really attorneys, but I imagine even people that don't have attorneys especially make huge mistakes. Before we do that, though, I want to say that the last time that you were on Exhibit A, we went over your Quadrille Counsel company, and this past week I got a chance to look at it again through the webinar you offered. And I was amazed at how far you've come along. I mean, I told my daughter, who's wanting to be an entrepreneur, I said, look at Louise Nixon. I said, she's worked on it, she's improved it, and now it's like an awesome company. And the features that you have on it are really way further than what you started off with. So obviously, you've got a commitment to excellence. I thought also, Louise, is that you provide the customer support. And that was really obvious to me by the webinar. The people that were in attendance of the webinar, some of them were your customers, right? Your clients?
Yeah, the subscribers were on for sure. And you know, that's one of the things that is also really needed if you're a family law attorney, especially, and you're stuck. If you're a subscriber and you don't even know where to even start on a matter with a retirement, you can email tech support, or not tech support, it's QDRO Counsel support. If it's a technical question, we'll help you with that. If it's a legal question, it's going to come to the experts and we're going to be able to answer it. So it's a great resource. It's, you know, we're not attorneys in a case. We're acting as general information that we're able to provide based on you know, whatever particular plan is based on what we know. But it's a really great way. And we found that for family law attorneys especially, they get this information at their fingertips and they're really happy about it.
Yeah. So, of course, having a great company means you've brought in the very best people. You've brought in my good friend Carlton Mays, who I've known for years. I didn't know this until, you know, maybe 5 years ago or something, but the two of you grew up together, right, Carlton?
We did. We go all the way back to, we used to call it junior high school then. It's now middle school, so it's been a long time.
Yeah.
Same class.
Yeah.
Oh, and
Yeah, it's just Louise was in a different level of classes, I think, than I was in.
She was law school bound.
Yeah, that's a long time ago for sure. But we all grew up together.
Yeah.
So let's talk about the common mistakes people make, especially attorneys, in handling quadrille issues. And what I did is I took a look at the outline, and I don't pretend that I'm anywhere near competent to do quadrilles myself, unless, of course, I use Quadrille Counsel. But here's some of the mistakes that you mentioned. You talk about one of them is get the plan name right. What does that mean?
Yeah, so one of the biggest problems is we'll get judgments that are filed that say, divide the community property interests in the Fidelity 401k. And unless the participant is an employee of Fidelity, Fidelity is the custodian that administers whatever the plan name is. And I mean, this is just so common, and yet too often the plan names in the judgments are not correct. And in most cases they're fixable, but sometimes they're not. And some courts are going to require a modification of the judgment. And it just helps the parties know exactly what they're dealing with. A lot of times because we have a questionnaire on the website, it triggers questions that you wouldn't think of asking. For instance, you may know about the Fidelity 401k, but it's really some employer, ABC company 401k. But because you've identified the employer, it also, through our finding plans, you'll be able to get the name of perhaps a second plan that you would have missed entirely. You, meaning the attorney, but the parties too. I honestly believe that participants, they don't know the difference and they don't know what they have. They may know they have a 401k because they're funds that they're contributing to it with maybe some matching from the employer, but they think that, most mid to large companies have a defined benefit plan and a defined contribution plan. So they have a type of plan that's money is being put aside in an account that's called a 401k in a lot of cases, and another type of plan where they're going to get a monthly payment for the rest of their life. And that's the $1 million asset. And that gets missed because in many cases that's employer funded. So unless you know that plan name or you know how to look it up, which we have a huge database that can help you do that, it gets missed. So so finding the plan name kind of goes in conjunction with making sure you don't miss a plan. So they're two, they kind of go hand in hand.
Okay. That's very helpful. So one of the basic things that I learned is there's a definite difference between defined contribution plans and defined benefit plans. Something very basic, I guess, for us family law attorneys, but certainly that's one of the things that you're talking about, right? Is confusing the jargon and not really knowing how one operates over the other. Right.
And how they operate depends. I mean, you would, it can impact the case and in settlement, it can impact the case and, equalization and offset if you're doing that. So it's important to know the type of plans you're dealing with.
Okay. Another one that I picked up from your seminar, we're not going to go through all of them. You guys were very detail oriented, and but I got some finer points from it. One of them was the language concerning division of a defined contribution plan. If you get the language wrong, then you could be in a lot of trouble, right?
Yeah. So right now, especially, that's a huge problem because what happens in the judgments, you have an award, a percentage or set amount, and a lot of times there's no reference to whether there should be gains or losses, investment earnings or losses. So where we see the biggest problem is if there's an equalization of some sort or some amount that is awarded in the judgment and there's no mention of it, and the account plummets and goes down, which has been the current situation with COVID, or the account increases and there was no intention to pay the X and increased on any gains or losses on that amount. So the easiest thing to do is just write it in with gains or losses or no gains or losses. And QDRO Counsel has language, for judgment language, that will force you, and not force you, but you'll have to choose between one or the other. And so you'll know for sure, whatever you've decided, whatever the parties have agreed to or the court orders, that you're going to have the correct language to protect yourself. These come back. I had a case in January where there isn't enough money in the account to pay the set amount, let alone that would it be fair to pay that amount to the X. And there was no mention in the judgment of gains or losses. And now it'll go back to court after the court's open because they've got to deal with that issue. And it's all post-judgment. So that they had thought about it before, but nobody plans on a global pandemic when they're drafting these judgments. I mean, most things are you can account for a lot of things, but you can't really account for what's happened since March. So
it's interesting, Don, if I may interject, is that another thing that's come up that our valuating side of the business has talked about is because of the pandemic and the reduction or the softening of restrictions on your plans and 401ks is loans, people taking out emergency loans. And if that happens in the time frame, how to deal with it.
Yeah, I'm thinking right now for people in the audience, you might have been divorced 5-10 years ago, and you never really understood that these things are supposed to be divided. Now might be the time to look at the Quadrille language of the judgment and revisit it, so that you get your fair share of things and you take care of business that was never done. You got a lot of time on your hands right now, right? Now, when you talk about the pandemic, I think actually this could be a good time for people to revisit things like this, don't you think, Louise?
Yeah, it's kind of crazy because it is coming up. I don't know if you saw in the webinar because we wanted to talk about it, but I got a call from a reporter from Bloomberg that wrote an article on it. I mean, the whole issue was, what is the impact on people's retirement benefits with QDROs because of the pandemic? I mean, this is a very troubling issue, and people on both sides, depending on how they structure their judgment language, are impacted negatively or positively.
Yeah.
So
In your seminar, you talked about issue spotting. And can you talk about some of the things that a layperson certainly wouldn't know to do as it pertains to contribution plans and defined benefit plans?
So the most important thing is if you can figure out at least who the employer is, you're on the right track to figuring out the plans. And then that's one of the, I mean, that seems obvious, but it doesn't happen a lot. But probably for the most important thing is whether there is, for a defined contribution plan, whether the participant contributed to the plan before marriage. What we call the separate property premarital interest in California is a big issue. And a retirement plan will not handle the calculation to determine what that separate property is and the gains or losses on that. And so if those aren't dealt with before judgment, and I would say half the judgments we get, they are not dealt with, then they come to us and they think they're done in the case. And then I was just, QDRO, can you do it in a week? And we say, well, yeah, but what about what you contributed before marriage? You said you've been in this plan for 10 years before marriage. We need to resolve this issue. It would be great if all of that is handled before judgment, because it really is opening up a wound for these people who think they're done, and then they have to live with resolving these issues for, sometimes it takes a month, a year, sometimes we have to go back to court on it. And I'm brought in, and I just did another one where I had to appear in court as an expert. We ended up being able to settle, but it could have all been handled before judgment.
I think I heard something in the webinar too, that you don't want to leave it to the plan to decide what your community interest is in, right? I mean, you kind of want to determine that before you submit it, right? Yeah. So if the separation was a long time ago, you want to deal with how the plan may calculate it. I mean, QDRO Counsel has the ability to help with all those things, but I think the most important thing is to just ask the question and spot the issue. If the parties don't have any values, and because a lot of times it's really hard to know what the value is at date of marriage, there's no statements. They've disappeared into a black hole, and it was 20 years ago, and you don't know. But if the parties can agree on the amount, a lot of times we can do an estimate based on the S&P and figure out what it may be. And a lot of times we're able to reach agreements on these things with people, and it's a good thing. Well, there were two final things I want to definitely talk to you about that caught my attention. One was excluding or including loans. I thought never occurred to me, but that is something that somebody could get ripped off pretty bad if they're not paying attention, right?
Yeah, it's interesting because I see judgment language where they try and grapple with it because they know there might be a loan, but there's some standard language, and it's very kind of counterintuitive in how it's stated. But for most plans, most QDROs, you're going to the amount of, it's even hard to explain without showing an example, but the loan amount, if it's excluded from the amount to be divided, the alternate payee, the non-member spouse, pays his or her share of the loan by taking a lesser amount. So let's say the loan is $15,000, or the total account balance is $15,000, and there's a $5,000 loan. The non-participant would take her share, his or her share would be 50%, if the award's 50%, in most cases it is, 50% of 10,000 instead of 50% of 15,000. The participant will always be responsible for the loans, but then the participant, because they get the increased value that's not paid to the non-member, but they just pay themselves back because they're putting the money in as all separate property and they're paying themselves back with a loan. So that's the default position. That's what you would want to do in most cases. But if loan language isn't included in the judgment, if it's not clear, if loan language is not included in the QDRO, it'll probably be rejected because, or they'll have a default that may not be what the parties have agreed to. So it is important, and it's not something that's talked about a lot.
Yeah, first time I've heard it. I'm just thinking about all those wily characters out there that they know the divorce is coming, and they start getting loans. They're taking loans from their retirement.
Well,
I am not teaching anybody, Louise. We're not teaching anybody how to defraud the system, okay?
No, but just to be aware of for your audience that now instead of the cap on a defined contribution plan at 50,000, it can be 100,000, and a participant can also take, while still employed, because of the CARES Act, $100,000 withdrawal, and that is my biggest fear. And we're going to see that happening, and nobody's going to know that, you know, unless if the participant decides he or she doesn't want to follow the temporary restraining order in effect before the QDRO is done, that could impact the ex-spouse's share.
Yeah. Okay. And the last thing that that really always bothers me is the survivor benefits aspect of all of this.
Yeah.
There was a stern. I don't want to call it a warning, but really a heads up with regard to that in the webinar. Can you speak a little bit about survivor benefits and why people make mistakes concerning not including them?
Yeah, I loved how Lorena Duffy is my partner at QDRO Benefits Law Group and also Vice President of Sales, or not, no, Carl's Vice President of Sales. She's part of the legal department in QDRO Counsel, right? So we're two different companies. And she did the talk, and I loved how she said, I mean, this definitely, survivor benefits just include a sentence on it in your judgment. It doesn't have to be pretty. We have language in QDRO Counsel that will make it very robust and you know, you're covered. But if you don't mention survivor benefits right now in California, if there is a death, or if the participant retires, you could cut off the right to survivor benefits. It's a problem, and we get the calls post judgment, post death of that happening, and a lot of times we can't take the case because we can't help them. The funds, based on current case law, automatically vest if there's a second spouse.
Okay.
Second spouse.
I think that we talked about a lot of nightmares here, right, for people. Now let's talk about.
I know. Yeah, there's a lot of good.
QDRO Counsel is here for you, right? I mean, there is help there. You don't have to be operating in the dark anymore because you created this wonderful program that people can plug into and get these things done in a professional way. You know, and family law attorneys could do it in-house. So Carlton, tell me why family law attorneys should be looking at this and saying, hey, I'm on it, man. I'm getting QDRO Counsel.
Well, I think the biggest immediate benefit is that you get Louise's office as your back office. Everything that she mentioned about the support ticket system is going to all the different experts, depending on what the subject is that you need assistance with. So you have that support backing you up. The other thing too is the money to be made. You know, if you're not aware of it, but most family law attorneys outsource this component of the divorce case or the dissolution process, and somebody's going to get paid to do it. So you might as well, as a family law attorney, keep it in-house and make the money yourself. Virtually, what is it, 80%, I believe, of every marriage has at least one plan that's associated with it. And now with typically two-income families, both parties in the marriage have it. The other thing too and Lorena, who Louise mentioned, that I think she said it quite a few times, but as you dive into the program, and you can deep dive because everything is explained in it. It's basically Louise's brain got picked clean and put into a box, and it's in the program. And then of course the evaluators, Moon, Schwartz, Madden side of it, which is the calculation suite. but it really isn't hard. I think people, and when I say people, I think family law attorneys are, they do things the same way for many years and they're adverse to change. And it's not that difficult. I can do a Quadrille, and I'm not an attorney and didn't have a law background, but after a couple of tries, I shaved about 15 minutes off it from the first one to the second one, just doing it myself. So a lot of benefits.
Cool, cool. Well, Louise, if somebody wants to find Quadrille Counsel, what's your website?
So it's quadrillecounsel.com. So QDRO and we are, during this crisis and as a promotion, we are offering 30 days, unlimited access to the website to try it out and see if you like it. The one other thing I want to say is we have a tool called the Notice of Adverse Interest, which I would recommend, and we're giving unlimited access to that on your previous cases. If the Quadrille hasn't been done, or if you have one coming up, to give the plan notice so that the member, if they're in a financial crisis and they're thinking of taking a loan, withdrawing funds, or retiring, I didn't even cover that. If they retire, it can impact survivor benefits. That the plan, in most cases, will put a hold on the account, and it's not something that has to be filed with a court. In fact, it isn't. It's just a notice that's sent. We have that automated on the site, and it's a huge. It's used a lot by attorneys to protect, especially if you're representing the out spouse.
Awesome. Well, Louise and Carlton, you guys were great again. Thank you so much for joining us. Thank
you for all you do.
We'll follow up with you in another year from now. I want to see, you're going to have clients around the world probably before you know it, certainly internationally. So
for more information, visit us.
Thank you again, and thank our audience for joining us on Exhibit A.
For more information, visit us at PasadenaLawOffice.com.